1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်29 MAUNG KHET and two others appellants versus mention respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Second Appeal before ဦးစိန်သင်း Judge MAUNG KHET and two others appellants versus mention respondent Succession application by the grandchildren of the father of adoptee application by the younger sister of the adoptee propinquity of the relationship of the rival applicants to the adoptee. Hell, the adoptee left behind a near relative in the person of the respondent, who is no other than his own natural sister. The appellants, on the other hand, are the grandchildren of the deceased, MAUNG, and as such, the degree of propinquity between them and the deceased is remoter than the relationship between the respondent and her brother. That is also an additional reason why the respondent ought to succeed to the estate of her brother. It appears that she had all along been living with her brother and that she had attended him in his illness. The last funeral rites of the deceased were also performed by her. MAUNG versus Manni, UBR, Volume 2, 1897, 1801, page 104. Mathan versus Massey, LBR, Volume 5, 1909, 1910, page 89. Masan Lama versus Jorton and Du, Ainchanton, LC, page 279. Refer to Umya Singh for the appellants, for the respondent. Usain Din Judge. Simple as are the facts out of which the present appeal arises a low point of considerable interest present before me. The applicants are the grandchildren of one MAUNG, who during his lifetime had adopted MAUNG, brother of the respondent, as his legitimate son. After the death of MAUNG, his adopted son, MAUNG, inherited his estate. MAUNG remained a bachelor till his death a few years ago. The question now arises to who should succeed to his estate, the contest being between the grandchildren of the adopting parent MAUNG on one side and the younger sister of the adoptee MAUNG on the other. One of the principles governing the rules of adoption is clear in that the adopted child draws out of his own family and lost all right of inheritance therein. In MAUNG versus Manni 1, it was observed that an adoptee draws even more completely than a deceased child out of the original family, for the deceased may leave children of his own who are admitted to a certain share, which does not seem to be the case with the children of the adoptee. It was also held in the case of Mathan versus Massey too that under Burmese Buddhist law, the right of inheritance of an adopted child are not limited to inheritance from his or her adopted parents, but extend to inheritance from collaterals in the adoptive family. Thus, the law seems quite settled insofar as the right of inheritance of the adopted child is concerned, but not so certain is the law when it comes to the question regarding inheritance to the estate of the adoptee, on the basis of the incident of adoption that the adopted child draws out from the original family more completely than that of a deceased person. It would appear that on his death, his natural relative would not be entitled to any share in his estate on the ground that they have become, in the eye of law, total stranger to the deceased. But the theory that the adopted child completely draws out of the original family is apparently founded on the following consideration, which were explained in MAUNG case cited above in the following terms. The adopted child draws out of his own family and is provided for in that adopting him. The expectation and arrangements of the members of the family he has left are framed accordingly, and it would be manifestly inequitable to let the child adopted into another family come back into his own and disappoint the reasonable calculations for the future which have been made therein. The number of prospective co-partners in the inheritance of the original family is reduced by adoption, and the adoptee cannot be permitted to come back and, as it were, to be born again. Thus, the legal fiction by which the adopted child becomes a stranger to his natural relative is meant only to safeguard the interests of the remaining members of the family out of which the adoptee has been dropped, and it should not therefore be extended beyond what was originally intended for. In other words, the adoptee should not be regarded as a stranger to his natural relative for the purpose of determining the question as to who should inherit his estate, although for the reason stated above, he should justifiably be regarded as a stranger for the purpose of shutting out all his claim in his original family. Again, the right of an adoptee to inherit from the collaterals in the adopted family is based on the consideration that adoptee lost all rights of inheritance in his natural family, and it seems inequitable that he should obtain in return only a limited right of inheritance in the family into which he was adopted. It is also recognized that such right on the part of the adoptee would not cause hardship to the relatives of the adopting parents, since they are in no respect worse off than if a natural child has been born. Thus, it seems clear to me that neither the theory that the adoptee draws out completely from the natural family nor the recognition of his right to inherit from the collaterals of the adopted family could be taken to mean that, for all purposes, the adoptee must be identified with the interests of the adopted family alone. There is that of direct authority on the question whether or not the relatives of the adopting parents would be entitled to inherit on the death of the adoptee to the exclusion of his natural relative. No doubt, in Masan Lama versus Jorton and 2-3, it was ruled that the mother of an adopted child succeeds to his property to the exclusion of his brothers or sister by adoption. But in that case, it was not contended that the brothers and sisters by adoption had no rights of inheritance from their adopted brother. They were excluded merely because by Buddhist law, a parent inherits before brothers and sisters. The only reference, so far as I am aware, to such a question is to be found in the leading cases of Buddhist law by MAUNG, where the learned author, after discussing the right of an adopted child to inherit from his collaterals in the adopted family, has this to say at page 144. Conversely, the relatives of the adopting parents would be entitled to inherit on the death of the adopted child without nearer heirs. Underline is mine. The learned counsel for the appellants, relying on this excerpt, contends that his clients are entitled to inherit the estate of the deceased to the exclusion of the respondent mentioned, but even applying this principle to the present case before me, I am of opinion that the appellant's case must fail, for the rule cited above only said that relatives of adopting parents would be entitled to inherit on the death of the adopted child, provided the adopted child did not leave behind nearer heirs. In the present case before me, the adoptee left behind a near relative in the person of the respondent mentioned, who is no other than his own natural sister. The appellants, on the other hand, are the grandchildren of the deceased, Bong, and as such, the degree of propinquity between them and the deceased is remoter than the relationship between the respondent and her brother. As pointed out by the learned judge of the lower appellate court, there is also an additional reason why the respondent mentioned ought to succeed to the estate of her brother. It appears that she had all along been living with her brother and that she had attended him in his illness. The last funeral rites of the deceased were also performed by her. In the circumstances, I would hold that the lower appellate court is justified in holding that the respondent mentioned is entitled to succeed to the estate of her brother Mountain. In the result, this appeal fails and is hereby dismissed with cost, advocate fee, fees at 1 go moha.